All right, good morning. We're here on Beacon Sales versus Ricci. Let me tell you all this. We already have let me have appearances, please.
Your Honor, Jose Casal and Stephen Warren of Holland and Knight on behalf of the plaintiff, Beacon Sales Acquisition Inc.
All right.
Jennifer Hernandez of Avila Rodriguez on behalf of Robert Ricci and Mirta Valdez.
Okay. All right, good morning. We already have April 6th at 10:30 a final case management conference. I'd rather, frankly, as opposed to a 5-minute motion calendar, discuss everything on that date and time. We got a half an hour there. So talk to me about that.
You understand, Judge, and we thought that that might be something that the court would recommend. The only question or the only concern we have is we have some deadlines that are coming up. Specifically, for example, if the court recalls, the court extended some of the pretrial deadlines 14 business days as a result of our efforts to try to negotiate a settlement with SRS, which obviously was successful. So that, I believe those 14 days expire on March 30th. So at least with regard, for example, to responding to Ricci and Valdez's motion for summary judgment. So we're going to need a further extension of that. We would like to have a further extension of that so we could first have the case management conference and express to the court what we think are the things that need to be done going forward in this case.
Well, briefly, tell me what needs to be done, what still needs to be done.
Well, again, it is our belief, Judge, that because of the SRS...
Any fact discovery depots?
No, that's been completed.
Okay. Any expert witness discovery depots?
That's something that we are in the process of considering whether expert testimony is going to be required as a result of this the case now being streamed.
Well, I agree. I mean, we got a July trial date, so
I understand.
now's the time to consider it.
And we're considering it, but the thing that what we wanted to do, Judge, to simplify things for the court and for the parties, is to amend our pleading.
To your motion to amend prior to that.
Your Honor, our issue, we have no issue with the case management conference. The issue here is that Beacon chose not to file a summary judgment against SRS or our clients. Now in the request, which we'll probably address later when they move to amends, they're asking to amend the pleadings and then perhaps have a second bite at the apple to file a summary judgment that they didn't previously file. Our position obviously is that's entirely prejudicial to our clients. Amending the pleadings to change any of the assertions or claims against
Well, it is
our clients.
interesting to try and amend at this particular
Yes,
point.
Your Honor,
We set
especially
for trial
because-
in July, especially when it's a 2014 case, so, but we'll address that in when the appropriate motions and response to that are filed. So, here's what I'm going to do. I'll extend any, the currently open deadlines until April the 6th, and we'll talk about it on April the 6th. Okay? So we'll see. All right, so I'll see you all at 10:30 on that date.
Thank you, Judge.
Okay? All right, great, thank you.
Number one, Justice Court Order number 1. Good morning, Your Honor.
Your court call or court
Mr. Rosen,
please ensure that you're dialing in a landline and be prepared to provide your name, the name of your judge.
says he's a garnishee, RBC International.
Good morning. May I have the name of your court, please?
Yes, this is Judge Thornton from the 11th Judicial Circuit of Florida.
Good morning, Your Honor. This is Benita. I'll be the operator assisting on court call this morning. Are you ready for your check-in?
Yes, ma'am.
We have Andrew Rosen connected at this time, Your Honor.
Okay. All right, Mr. Rosen?
Yes, good morning.
Good morning. All right, and then here in court, tell me who's here on Medics versus Man 11-21975, please.
Is real and Sosa calling tonight on behalf of the plaintiff.
George Biel on behalf of Luis Ruiz.
All right.
Judge, no full report on this case.
Okay. All right, so talk to me.
Your Honor, this is defendant Luis Ruiz's motion to compel with respect to a request for judgment that we served upon the plaintiffs. If the court recalls, it ruled in favor of Mr. Ruiz with respect to entitlement as attorney's fees against Medex. Now, we still don't have an order on that. but notwithstanding, a request for production was served and would request the plaintiff's billing records. The defendants served a response objecting that they were overbroad, et cetera. By response, we agreed to narrow the request to the specific dates of the proposal for settlement through the current time, and specifically advised them that they could redact any privileged or confidential information. Notwithstanding, they refused to produce any documents in
Yeah,
response.
because reasonableness isn't an issue yet.
Well, Your Honor,
I mean, is that accurate?
not really, because the court has already ruled in our favor as to entitlement. The court's own standing order sets a very, very, very tight schedule.
But the case law is clear on getting the other side's attorney's fees, that only when reasonableness is contested, do you get the other sides to have a comparison as far as reasonableness is concerned. So,
Your Honor, if I may walk the court through the court's own process, we have about 20 days from the date the court submits its order to provide the plaintiffs with our fees. In response, they have 10 days to contest them. And then the court rules. There really is not a window or time frame for us to now serve a request
well,
for
I'm going to
production.
give you the window or time because it's appropriate based upon the Florida Supreme Court cases.
So the specific ruling is, unless and until our fees, our request for fees is
So,
contested.
yeah, I mean, it's denied without prejudice until the issue of reasonableness is in play.
And when the issue of reasonableness is in play,
Then then we'll talk about that, but it sounds reasonable to say from January 30th to 15th of the present, and it sounds reasonable to
Redact privilege matters, but not the time spent. Assuming reasonableness is an issue,
I understand.
okay? So we're just not there yet, that's all I'm saying.
Your Honor, the truth of the matter is, we can't even agree on the time of day in this case. I think the court knows that.
You
We
couldn't
can't
during the
agree.
trial, I'm so surprised that you can't now.
So, I mean, I think it's just kicking the can down the road when we can resolve these things, but.
Consider it kicked.
Thank you, Judge.
Okay, all right,
Thank you.
thanks.
Number 3.
Counterparts for.
Good argument, by the way, Mr. Encinosa.
Thank you, Your Honor.
Hello, sir.
All right, what's the next one? Number 3? Okay. By the way, has there, are you here on Dak Hill?
Just number 3, Judge, is the court order.
All right, thank you, Mr. Rosen.
Thank you, Your Honor.
All right, we're here on Dak Hill versus Teppa Group, 16-14935. Let me have appearances, please.
Yes, Your Honor, for the plaintiffs, Brian Torres and Nicholas Jimenez.
All right,
For all of the defendants, Michael Stewart.
okay. All right, now, has there been a response to the motion to enforce the settlement agreement?
There is not.
Okay. All right. Let me hear from you briefly with the understanding that this is a 5-minute motion calendar upon which a motion to enforce a settlement agreement is set.
Well, on that issue, Your Honor, we were advised by your case manager that ordinarily put these types of motions first on a motion calendar, and if you feel like you need to have a special set, then you
Okay.
do so. That's the reason we set it.
All right,
in
well,
this
that's
manner.
why I was secretly hoping that there would be a response too, so I would know before I got here, but,
I will have
you know,
a response.
okay.
Okay, so, well, if Your Honor's read the motion, you know that this case, which concerns LLC, mismanagement and claims brought on behalf of the plaintiffs who are members of Teppa Group LLC, the parent company, was sent to mediation per the case management order that Your Honor entered, and we had a mediation in December, which resulted, as the mediator reported, in a full and complete settlement of all the claims in the case, by which the defendants would be buying out my client's 40% interest in Teppa Group for $1.275 approximately $1 million. And the settlement agreement's been submitted at Exhibit B to our motion, Your Honor. It was signed by representatives of all the parties. And the issue that came up with respect to the settlement was that if the collateral for the settlement, which was supposed to be initially just the restaurant property that was at issue, was determined to be less than $6 million, then Mr. Arcaro would be required, one of the named defendant and the manager of Teppa Group, to also include his home property as collateral. And we received the appraisal. My clients paid for the appraisal and received it, and it came back at $3.5 million. So at that point, the parties began to attempt to negotiate an amendment to this agreement that would address the inadequate security that my clients saw as a result of the appraisal, because the total hard assets, putting aside the personal guarantees that are required to be given by the defendants and their spouses, would be inadequate to cover the entire debt. So we had some discussions, and I think we worked in good faith, and that includes defendants as well, in trying to address this shortfall in collateral, but those negotiations were unsuccessful. And we're at the point now where my clients, never having terminated the settlement agreement, want to stand by it, and the defendants at this point are, as far as I understand, unless something's changed overnight, not willing to proceed with it. So we're asking the court to enforce it, because all the material terms were agreed to. You have the agreement in front of you, and that's why we're here today.
Okay, we're going to actually be requesting a special set hearing. At the time the agreement was entered into, we wanted to go forward. There's a condition in the agreement that if the appraisal did not turn out to be what it was, if it didn't get to that certain level, the plaintiffs could cancel the agreement. What happens? The appraisal comes back low, the plaintiffs come demanding for 2 months, we want this, we want that, we want not to get into the settlement negotiations, but they've effectively, by action, canceled the agreement. That 2 months cost my client approximately $57,000 a month in operating costs. We can testify to that in a special set hearing. Our position is that they are stopped at this point. They got the appraisal back, and then they're demanding additional collateral not included here. This agreement says if it doesn't come out to $6 million, he has to put up his house. That's not what they wanted. They said the house is not enough, and they went on and on. They effectively canceled the agreement.
So that's going to be the issue of fact, if that's their position, Your Honor. That's the first we've heard that. So if that's the case, then we'll be happy to address that. We've got all the email correspondence, and we'll be certainly ready to testify as to that issue. It was never canceled. There was no notice of termination ever given.
They're trying to have it both ways. Drag us out for 2 months, make us spend money, and then later, when they're not giving me what they want, they say, oh, we never canceled this agreement.
How soon could we be ready to go on this hearing?
We could be ready, Your Honor, as soon as you're able to set it. I'd like to wait for my co-counsel to return from his vacation, but that'll be this week. And I'm assuming we're not talking about this week.
I don't think we're talking this week. This is the best. I never get to get into mediation, matters that are covered by the privilege. And it's Mr. Morales, who's right down the street.
Right down the street.
We should bring him here, have him come. There's a Starbucks on the way to his place. We can all get some Starbucks. And here's what I'm going to do. Let's see.
I will be away the second week of April, but that's the only other limitation I'm aware of.
Okay.
And of course, we want to make sure our clients are available.
It's a great time for desktop not to be responding. Okay, here we go. Y'all have your calendars out?
Yes.
Yep.
All right, the week that you're not here is what? Is the April the 10th week?
That's correct for me, Your Honor.
All right. What's your gut as to how long you think this is going to take?
3 hours.
I wouldn't think more than 2 or 3 hours, as Mr. Stewart said.
I mean, I was thinking a half a day max.
I mean, I think you're looking at some brief witness testimony, and there's going to be correspondence that Your Honor's going to want to review as well. But I think all of that can be done within 2 or 3 hours.
Look at Thursday the 20th, please. In the morning. I mean, I can do it starting at 9:30. That's 2.5 hours.
I'm clear that day.
I have a short family trial that morning, family matter, on the 20th.
What time is that? Do you know? Who's it in front of?
What time is the trial start? 10 a.m. in front of which judge? You know?
What about the afternoon before, the 19th? At 1:30.
We're available, Your Honor.
I'll be
Available? Okay. All right, let's do that, the 19th at 1:30. I want you telling each other who the witnesses are, who's gonna be called, whatever documentation. If, I want you doing one additional thing before that, before the hearing. I want you all sitting down with Mr. Morales in an attempt to resolve it prior to the 19th. So it's gonna be 4/19, and I want a written response from you, okay? 4/19 at 1:30.
Your Honor, may I suggest that some reasonable deadlines be set for these issues? Perhaps a week before for witnesses and documents prior to the hearing?
Well, let me hear from you on that.
I mean, that's fine.
I mean, because I'm gonna want you to both sit down, I mean, it should be fairly straightforward and simple, I would think.
Yeah, I mean, we
You
can-
know,
we
but I
can-
do want you both talking, either on the phone or in person, exchanging both the witness lists and, at the same time, and whatever documentation you've got, okay? And, you know, and at the hearing itself, keep it right to the issues. We don't need to get too carried away, so.
Why don't we agree to exchange documents with us by the end of this week? And then set a meeting around Mr. Morales before, or as soon thereafter as we can.
I mean, my suggestion is, do you all have a hearing right now in this building? Why don't you walk down to Morales, it's a half a block, it's a half a block. Mr. Morales' office,
Well, yeah,
or you can call him.
yeah, I'm just down the street too. Just need my clients here, that's all.
Okay, gotcha. Okay, all right, great. I'll see you all on the 19th at 1:30.
Thank you.
Okay, thank you, Your Honor. We'll send out the notice.
Please, thank you.
Can you do 10 o'clock special session? Everybody see it?
Let me see, okay, there's nobody on New National, 156120? Good.
No, nobody else.
Okay, good. The 10 o'clock why don't you all get set up? And then I'll be with you in just a moment after I get the paperwork.
No, I was, no, they wanna